Francisco Torres.
Hi.
Okay. The second presentation is on the subject matter is protection of intellectual property of ship construction or industrial property of ship construction. Francisco Torres is a PhD and assistant professor of maritime law. He is specialized in international maritime law. He works for the University of Vigo and permanent collaborator of the insurance section of the Journal of Transport.
Thank you so much for inviting me to this student course. And I'm very grateful to the Professor Igor for his confidence, and congratulations to the organizer for organizing this excellent course. And thank you, Professor Alex Ruttenberger and Professor Tuapo, for your support and for your presentation. Well, the title of my presentation is Protecting Intellectual Property in Construction. Maybe it's a little bit late to this topic. We would prefer to Martini Rosso Bianco topic, okay? But I try to go quickly and brief in this extended topic, okay? Well, this is my contact details. You want to have contact with me. This is a brief outline of my presentation. And if you allow me, I will start with four basic introductory ideas of this topic. First one, from a legal point of view, one of the most relevant uses in the European naval industry is the protection of the intellectual and industrial property rights to guarantee technological and competitiveness. Well, legally, the protection of these intangible values, which includes parts, processes, and know-how, is essential. The protection can be done through patents, industrial designs, and trade secrets, but also through trademarks and copyrights. But this is the second idea. In practice, the shipping industry is one of the industrial sectors in which industrial property rights are used as less, and where European companies suffer a greater impact from infractions and other unfair practices without the possibility of effective defense. And why? Because two reasons. So the traditional confrontation between the protection of industrial property and free competition also exists in the field of the maritime sector. This is the debate. A very strict system of protection of these rights that put obstacles in a normal commercial traffic is not desirable. But on the other hand, the total lack of protection of innovative companies that invest in development will discourage or not incentive the investment. Well, the second reason, the other reason is the international patent system has served as a basis for regulating other industrial property rights. This system is not attractive because it has a limit, an exception to the infringement, as we will see in a couple of minutes. Well, this weakness is compensated in two ways. In many cases, the shipyards opt for industrial property rights that don't require an official registration. We call it unregistered design. Also, the shipyard opt for keep the most sensitive information secret, and for that use the law of the contracts. For example, through clauses in the constructing contracts known as non-disclosure agreements or confidentiality clauses. This type of clauses are very present in the shipbuilding forms. Well, the third introductory idea is what do we refer or mean with the expression industrial property? I'm sorry for being too basic in this topic, okay? So industrial property could be defined as a set of intangible assets that allow the holders to exercise some exclusive rights over an invention, patents, a drawing, or a three-dimensional model, industrial designs, a sign that evokes in consumers business origin, trademarks, or confidential information through industrial secrets. Why do we, in these cases of industrial characteristics derives from its practical utility and its consequent application to industrial manufacturing processes? Well, by general rule, these intangible assets must be registered in a public register, national or supranational register. This need for registration is a common characteristic to most industrial property rights. But it is very important to say that beside the rights that need registration, there is a second group of industrial property rights for which the registration is not an essential characteristic or a constitutive element. The most relevant is that these are the most used intellectual property rights in the field of the shipbuilding because they are free and don't require disclosure. So, in addition to the industrial property per se, we must mention the protection via intellectual property in the strict sense, which in continental countries we identify with copyright. In the case of ships, some objects protected by intellectual property, like the construction plans or the software for the onboard computers. Well, the fourth idea, as a closing remark of this point, is the following. We must remember that the design and construction of the ship are affected to many regulations related to the safety, ecology, or capacity, among others. Well, these conditions may come from the international regulations, such IMO regulations, ISO standards, and these impositions exist from the initial stage of the construction of the ship. And in addition, there will be a review of all stages of construction by the Classification Society. Well, advanced these introductory ideas, I move on to the existing legal framework in the international field. Well, at the international level, we have the following international conventions. The first one is the Paris Convention for the Protection of Industrial Property. And the second one is the Agreement of Trade-related aspects of intellectual property rights. While this presentation, we will focus on patents and the solution provided by the Paris Convention in relation to the ships. Well, in this matter, the fundamental solution, the fundamental article is Article 5.1 of the Paris Convention, as introduced in 1925. So remember that I told you before, this convention, this article, focused on patents, serves as interpretative guide to other industrial property rights related to the maritime fields. Well, the introduction of the Article 5 in the convention. Sorry. Derives from two cases of United Kingdom and United States. Later, a similar solution was introduced in the Paris Convention through the Article 531. This article has adopted the characteristic of reciprocity, since it applies of the signatory states of the convention, and is characterized to the absence of any reference to the nationality of the vessels and its determination. The clause is called in English temporary presence exception. Well, here we are. What requirements must be complied to apply the exception? That means so that there is no infringement of patent right. Well, three requirements or three conditions. The patent must have as its object the hull of the ship, machinery, tackle, gear, or other accessories. The objects covered by the patent must be used exclusively for the needs of the vessel. The objects to which we have referred in the previous point must be essential for the ship, for the mission of the ship, not be secondary or ornamental or unnecessary. Some authors consider that from a negative point of view, it can be understood that something is necessary in the ship when its suppression or withdrawal from it makes the ship lose its ability to navigate. Okay, and the third condition is that the vessel has temporarily or accidentally entered the waters of the country signatory of the convention. Well, the accidental entry due to a loss of cargo, a breakdown, or a health emergency, among other circumstances. This entry must be punctual. This means that once the problem has been solved, or in the face of more favorable navigation conditions, the ship has to leave the port. The consideration of temporary entry depends on the purpose of the trip. In this sense, entering the port with the only objective of continuing an international trade route is considered as a temporary state. On the contrary, it is permanent when the ship is dedicated solely to the transport of goods or people between domestic ports. Well, the conclusion of this regulation is clear. The current regulation framework doesn't allow national authorities to take action against a ship that has a component built in a violation of a patent and that lands in a port where safe patents is registered and protected. Well, the consequence of this system is that the registration of patents and the design of the ship, as we will see, is not encouraged in the shipbuilding sector. Besides of this, the competition is affected because the ship owners who assume higher cost because they search for patents and registered designs have a disadvantage compared to the ship owner who do not and for whom the infringement doesn't represent any legal consequences. Well, briefly, I want to simply point out the European regulation of the rights of patents, designs, and business secrets. The Paris Union Convention and its Article 5 have influenced the drafting of the national patent laws and later moving to the field of industrial designs. Regarding to patents, some countries, usually the countries that are signatories to the Convention of Paris, have transferred the Article 5 literally to their national legislation. So in relation to the industrial design, one introductory idea. Design, from the legal point of view, is the instrument of industrial property that protects the external appearance of products. The industrial design of a ship characteristic is very important for its proper operation and safety. So in relation to ships, the design protects the appearance, the structure, the more or less aerodynamic, attractive, minimalist character, and so on. Other components, part of pieces of the ship, can also be protected by this right. Also are very important that the current design of the ships is influenced by technical regulation or may derive from regulatory impositions depending on the type of the ship in question. Well, currently the industrial design in Europe has two possible ways to protect you. Registered and unregistered design. The first can be registered with the National Industrial Property Office or the European Union Intellectual Property Office, and always has a maximum duration of 25 years. It is initially requested for 5 years and is subject to a maximum of 5 renewals for periods of the same duration. For its part, the unregistered design is only regulated at European level. The unregistered design is protected for 3 years from the time it is made public on the market for the first time, so that it can reach minimum. So the unregistered design is very present in the field of maritime construction, shipbuilding construction, due to the great dynamism of the industry. It does not require any formality, step, an act of communication to the public, which may be, for example, the publication of photographs, the inclusion of the design in catalogs or internet pages, or the activities of marketing. Well, it should be pointed out that there is not reference to the design in the Paris Convention. It does not contain any limits or exception to the right similar to the Article 5 of Paris Convention, but it was considered that this article could be incorporated to industrial design via by analogy. Secondly, it is incorporated into the regulation of community designs, Article 20.2. So the exception or limit is constructed in industrial design is constructed in a similar way of a Paris Convention for patents. But there are two differences to point out. In the first place, the regulation of industrial design makes reference to 3 different actions: the equipment, the importation of spare parts, and the execution of repair work, which they have in common that they are carried out on the ship. So the second difference is that the design limit in the regulation is less specific because it refers to the ship's equipment as a whole, without making a detailed reference to any parts of the ships, unlike in the case of the patents. Well, let's move only a brief reference to the trade and confidentiality agreements. In the maritime sector, construction techniques, material and processes can be developed as a part of innovation carried out by the shipyards. As I told before, due to the lack of incentives to register a patent and industrial design, the protection of innovation comes many times from the industrial secrets. At the international level, we do not have an expression provision on the Paris Convention on Secrets. For these reasons, the developed countries sought new strategies to protect industrial property. The process culminated in the promulgation of the Agreement on Trade-Related Aspects of Intellectual Property, and this international convention protect the undisclosed information in the Article 39. Well, for its part, the European Union regulates the trade secret by the Directive on the protection of undisclosed know-how and business information against the unlawful acquisition, use, and disclosure. Regulates this topic practically identically to the Article 39 of the TRIPS Agreement. Also, the Spanish precept of the trade secret law derives directly from the directive. Well, only three questions to the trade secrets. Secret information or knowledge may be technological, scientific, industrial, commercial, organizational, or financial. Second, industrial secret, unlike patents, don't grant an absolute exclusive right of limited duration and subsequent access of the information to the public domain. The fundamental thing is that it can be kept secret indefinitely if its holders, CBRs or other companies, don't disclose it. And third question, the owner of the secret must adopt reasonable measures to keep the information secret. Among these reasonable measures, we find the confidentiality clauses in contracts, commercial contracts and labor contracts, which identify sensitive information and establish confidentiality obligation for the parties. Other two less used ways of protection will be copyright and fair competition. So the intellectual property regulation protects, as you know, all original, literary, artistic, or scientific creations expressed by any means or medium, tangible or intangible, currently known or that will be invented in the future. We highlight those creations more related to buildings that can be protected with intellectual property regulations. Projects, plans, models, and designs of architectural or engineering works, graphics, maps, and designs related to topography, geography, and engineering to science, and computer programs. So this right, as you know, has the advantage of being durable over time, the entire life of the author of the 70 years after his death, and lacking registration formalities since its registration is optional. One last line of defense will be the unfair competition, but I don't say nothing about it. Well, let's move then to the final part of my presentation, introduced in how are the mechanisms of protection in the shipbuilding contract forms. Well, I start mentioning two elements present in the common law and civil law systems and which characterize the civil contracts, as you know. The first one is the minimum regulation of such contracts. For example, in the Spain law, regulation of civil contracts provided by the Maritime Navigation Law contains only 9 articles, although the nature of this contract could be the work contract and could be regulated by the civil code. In the UK, it also exists a minimum regulation of this contract. So the second element is typical in the maritime law fields. Due to the freedom of contracting, operators usually use the standard international forms and adapting the forms to the needs of their clients, which implies problems of interpretation. Well, the most used forms, as you probably know, are in the slide. So regarding what is regulated in these forms, it is necessary to ask what is protected in these forms, who is protected, and what measures contemplate these forms for the violation of intellectual property rights. Briefly. So in relation with the objective, with the scope of protection and of what is protected, in all forms, there is a specific clause that under the different names regulates the protection of certain aspects of intellectual property linked to the construction of the ship. The scope and the objective and the extent of this clause is variable. There are contracts which literally seems to limit such protection to the patent law, and after that provide for a specific regime on the ownership of the property rights over the plans and design of the vessel. Other contracts are limited to patent rights, for example, Norwegian form or AWIS, although we understand that a broad interpretation of this expression that include copyright, trademarks, and patents. Finally, with a more practical approach, other contracts extend the scope of protection to all intellectual property rights to the construction of the ships, copyright, trademark, patent, or similar rights. But whatever form we choose, in order to delimit the protected rights in this type of contracts, we must make a joint interpretation of the contracts. For make this joint interpretation of the contract, it's necessary to take into account the discipline of the design contained in other clauses of these contracts. In particular, in clauses that regulates the eventual responsibility for defects derived from an improper design of the ship. Therefore, the protection will necessarily be limited to the intellectual property rights used in the construction of the ship, the installation of the components and or equipment in the same, and those rights that affected the design itself. So, on the other hand, in terms of delimiting their liability, the shipyards will not respond to any infringement of intellectual property rights on materials, equipment, or plans provided by the customer, the purchaser, or the buyer. This question is specifically provided in some forms. Well, with respect to who is protected, as a rule, will be the owner of the intellectual property rights that has been exploited during the construction of the ship. The most usual operation, as you know, is that the shipyard, the builder, design the plans and provides the materials and the equipment of the vessel, which, if it's necessary, will purchase, buy from its suppliers. In this case, the shipyard will be the holder of certain copyrights and holder or licensee with the right to the use of any patents or utility models or industrial designs or equipment installed on the ship. In conclusion, usually the shipyard is the first protected by this regulation. However, at this point, in terms of protections, we must evaluate other cases. As for design, for example, it might happen that the buyer contracts the design with an other company different from the shipyard. They call it design company. And such company, design company, transfer its right of exploitation or use to the client to be delivered to the shipyard. In these cases, in terms of copyright or any other right that may exist specifically linked to the design, some forms contains an express attribution of rights to the party that designed. And in addition, the attribution of rights is complemented by the following measures: the appropriate duty of confidentiality, a necessary right and consent to transfer such information, and something very important, a limitation of the right to exploit such rights, because that consent will not be required when the transmission of such information is necessary for useful operation, repair, and maintenance of the vessel. So on the other hand, it's also very common a third hypothesis. The buyer provides certain patented technological equipment. The buyer, in that case, must have a license to use it. If he does not have a license, the owner of the infringed right may claim against the shipyard. For this reason, it should be pointed out in the contract, as it is especially stated in some forms, that the obligation of respect of the intellectual property rights is mutual, and its infringement involves indemnifying the other party. Besides of this, the contractual protection indirectly also affects to the third parties, because the contract between the shipyard and the buyer doesn't imply the transfer of any patent or trademark rights or copyright in equipment covered by the contract. And all intellectual property rights, including the site of the vessel, are expressly reserved to the true and lawful owners thereof. Well, to finish, once it is determined who is protected by this clause, it is necessary to consider what measures does such protection. In some forms, the protection is configured as an express warranty granted by the constructor or by both parties in some forms. From a double point of view. So the first one, the ship will be built without infringing the patent rights, and that will be delivered free of this type of claims. In addition, all contracts provide an express indemnity after the transfer of ownership of the vessel to the buyer. The builder must indemnify for any infringement of patent rights or intellectual property rights. With these circumstances, the most common case is finding a violation of the intellectual property rights by the shipyard, which usually involves a claim or an action of any nature held by the third party owner of such rights infringed against the buyer. So regarding to this, I want to highlight only two final questions. The forms specifically provide that the compensation will cover the cost of such claims, of any claim and expense of whatever kind, or claims of patent infringement. In sum, given the broad formulation of the forms, we understand that this compensation will cover both direct damages and loss of profits, and indirect damages. However, when a maritime lawyer adapts these forms to the needs of the client and write a final contract, usually considers another issues. For example, that the builder assume the cost and measures from a possible arrest or any other encumbrances of the ship resulting from such claims, or consider, for example, that the builder must take any measure necessary to restore the free use and enjoyment of the ship or any part included in it, replacing, if it's necessary, the equipment that infringe the intellectual property rights by other that doesn't infringe. Well, only for finish, let me tell good paper that I read months ago, paper writing by a Croatian colleague, Moreno Pajovic, and published in the journal of the University of Dubrovnik, okay, that's more. And call it the possibility of applying the ship arrest measure in case of intellectual property infringement. It's a very good paper, and I try to finish this presentation with this quotation, okay? Well, sorry for my extra time, and thank you so much for your attention.